Abom ana esibu so Deputy Attorney General Dr. Justice Sham Sayakasa also received threat over the life. In fact, Wontumi some boy case in the 2 witnesses now say buy more security because they're also receiving threat or details. And the meeting in a remind them ever said the terraces as I don't call. And it's sad. Dentina Wontumi plea bargaining deal, no Wontumi strike a deal. Attorney General Deputy a boy amount to be. Payment sources are close, and this week I may be able to give you some document on that. And only an Exim Bank case, 30 million CDs. Dentin Attorney General says Sikana Wontumi de ban omuntimenye. Sikana send Attorney General pesa wajie. And no, any everyone command the critical analyst channel. Make sure to subscribe me. Or subscribe and click the notification with the video. We are to be you have a comment, feel free. Leave that comment in the comment section. Make sure so we have a Goldberg Construction Limited. The Dine episode sino. If you want to register your land, if you want to get all the right documentations for your property to secure your land at Goldberry, ABD Sage Manager Adama. Again, when you are building, you are abroad, you are sending money in, you are building a warehouse, a school, a hospital, and help us will be tracking or baby in academic performance, PTA meetings, school, Mokohunia, Kosuni Bibia, back of assess ABD Sage Manager at the amount. Yes. Now, Deputy Attorney General Dr. Justice Shamsa granting interview to Joy News on a lot of issues, oral cases. No se threat e ba no so no enya sem ketwa denti na plea bargain so Wontumi third case no Exim Bank case no munyi Wontumi sika no ni ochechire mu enye.
It's about good faith. I believe that as a defense counsel we should be interested in how soon this will end so that we even have more space next legal year, but that is not the case. Now let me take the other side. If the court holds that the submission of, dismisses the submission of no case and directs the accused person to open their defense, this is what is going to happen. The judge is bound to give the accused person 3 weeks to file their defense. That takes us into what? October. Still, this doesn't require to come to court to do any business. Then, after you file your defense, that is witness statement for your witnesses, then the court will set another day for what we call case management conference, which is usually another 1 week. So, even with this Edubuahin case, if the court is allowed to proceed as it's supposed to, there will be only 1 day in the legal vacation that there will be any court proceedings. The rest will just be filing, ruling, counter filing up to like November. So if counsel is telling me that he has booked so many things and that he's so busy that he can't do 1 more day, and yet is filing other cases in other courts, it tells you what is at play here. And it's not, it is not a question of legal vacation or not. It is a defense. It's a defense strategy, whether for good or bad. That I leave that to the listeners.
But basically, you say defense strategy to delay the case.
That is my candid opinion on this, because I don't see why 1 day of cross examination should be dragging us into this, especially when you are in other courts working and filing processes.
And Thursday, the Supreme Court will decide this and put some finality to the matter. Let's deal with some other oral cases. And before we come to specific oral cases, Wontumi, you succeeded in securing a conviction. He's behind bars now. He has filed an appeal, but he's also filed a process to get him out pending the hearing of the determination of the appeal. You filed to object.
Yeah.
Very strongly. Why? I mean, he's already been convicted. You know,
opposing such application is actually in the interest of the accused person. Accused persons, of everyone likes liberty. But think of a situation where you have been sentenced, you have served, let's say, a month, and then you are granted bail pending appeal. So you come and spend maybe 3 months or 6 months outside, and then the appeal fails. You go back to serve your sentence. You get the point. That is a psychological, there's literature on this part of it. So judges, unless there are exceptional circumstances, so for example, case of severe illness or some health issue or some very important matter, so we call it exceptional or special circumstance, then the court will grant you, but they will not grant you bail pending appeal merely because you disagree with the decision. If you look at the affidavit they filed All they are saying is that they disagree with the decision and they stated grounds on which they disagree. That does not occasion any special circumstances that will allow you to what? Come out pending the appeal. And so when it was pretty easy for us, because there were situations where if you take, I think, Ato Asian, he is on bail pending, I think he was put on bail pending appeal because there were severe health issues that were apparent on the face of the affidavit. This one has no such thing. It simply says, grant me bail to be out there because I won't run away. So let me be out so that you decide the appeal. It's pretty easy for the prosecution. So when we sought advice from our attorneys, they said, no, there's no sufficient, there's no special circumstance to warrant an accused person to be brought out. And then later when the appeal fails, you take him back in to start the sentence. So
and an appeal can take quite a while to resolve. So you're expecting that he's going to be behind bars until that is determined at an appeal.
Yeah, so the thing about appeal is that it is the appellant's job to fast track appeals. So appeals work in two ways. If I am the appellant in this case and I'm the accused person's lawyer or the convict's lawyer, I will do everything to fast track the appeal because these are the timelines. Once you file your appeal, the first thing you do is to compile records of appeal from the lower courts, and then you forward it to the appellate court. That is entirely in your hands. If you want to wait for 2 months to compile it, because the registries, they don't go on vacation, so they can compile it anytime for you to. So depending on how you fast track that, your appeal will end up in the court of appeal sooner than anybody would think. And then when is there are timelines. Once there's something called Form 6, or that's in civil case, but in criminal there's no such. It's a different process. But you go to the court summons you, you come there, and then they give you timelines. And usually it's just 21 days for you, the appellant, to file your address. You can file it on day 1 instead of waiting for the 21 days. You can file it on day 1 and serve it on your other party. The respondent has 21 days from the day of service. So if you want it fast, you can file it on day 1.
Have you been served that?
No.
You've not been served
the record is not even in the court of appeal.
Okay.
As far as we know, nobody has, the record is not before the court of appeal. So another side of the case is that if you secure, it's like a client who secures an injunction and then goes to sleep. So you are building on my land or on a land that is in dispute, and I go for an injunction against you. I know deep down that I don't have, title, but I just want to frustrate you. Once I get an injunction, I go to sleep. And then the injunction is working against you while I sit down and cross my legs. So it's possible that you can get bail pending appeal, and he will refuse to move forward appeal, and the record will stay in the high courts. He's on bail. And then it delays the process. So appeals could actually be fast-tracked depending on the counsel's interest.
So you're saying you're waiting for Wontumi to fast-track his own process as far as the hearing of the appeal matter is concerned?
No,
it's entirely in his hands. And you haven't been served yet with the...
No, it's only when we accept that we take a step. So we will sit down and wait for them to... If they do it today, the court will even give us a period within which to respond. And we cannot even drag it. Because if you don't respond, the effect is that the court will decide the case without your response.
Out of the court, and this is just, by the way, he's also been rendering apologies, to the president, and, appealing to the president to intervene, and that if he's wronged him in the past, he's sorry, his aides have been saying it. Does that count for anything?
I think there is a certain culture which I find disturbing. People still behave or don't believe that the judiciary is not under the control of the executive. That is what informs such, things as apology. So you have been charged with specific offenses. The judiciary has heard you, they've convicted you. You have maintained throughout the trial that you are innocent. You have even filed an appeal. Now, I'm not saying don't apologize to people that you believe you have wronged. But if the apology is engineered to secure an overturning of a court's decision, then what you are doing or suggesting is that the president has power to actually cause the courts to decide one way or the other.
Or pardon him, maybe.
Fine, pardon, but I don't think pardon has a process. People don't usually people don't see the process for pardon. Pardon, after you send your petition to the president refers the petition to the Attorney General's department. We look at it, we refer to the prison service, they also look at it, and they all write reports. So often you hear that the president has pardoned these people. It's not that you just tell the president gets up to say, I'm pardoning them. No, there's an elaborate process that goes on underground. I don't think the president, well, I'm not in the office of the president, but the president has not informed us that he has received an application for pardon. So that case, the prayer, the apology is not intended to secure a pardon, but intended to get the president to influence the judiciary one way or the other to let him go. And I think that is unfortunate because as far as I know, the president doesn't have that power to direct judges as to how they should decide. If such a power exists, I'm not aware.
I mean, out of curiosity, I mean, in this country, made the point that when somebody is put before court, due process is applied, and the person is punished, you tend to get all manner of people calling to appeal and plead. Have you received any calls, chiefs, pastors? They are anybody.
Well, the work I do, I have taken some oaths and oaths of secrecy, so I don't think it's something I'm allowed to disclose.
No, not disclose who, but people just randomly. Pastors called you. They want to pray for you so that you do something to them.
People threaten you with all manner of things, and you receive such threats every day. The mere fact that you are doing your work can cause someone to just hate you, and some threaten violence, death, and all manner of things. Some try to even carry them out, but it's not everything that we talk about.
Have you been a victim of a target of any of those sins? Because this is a major conviction. People are very upset.
Every day, someone somewhere is unhappy and is.
So have you received threats on your life?
Of course. I mean,
has it gone up or reduced since Wontumi's conviction?
It's actually gone up. Our witnesses are every day threatened with
the two of them.
Yeah.
The two.
Yeah.
Star witnesses.
Yeah. And even the police investigators who testified and all, they threaten everybody.
I see.
So but I think it comes with a job.
I mean, because I'm a manager, Joe, I know how severe the threats were and how direct. In your case, were they mere, sometimes we're just joking. How serious do you take those threats?
I take each of them very seriously.
What were they? Was it to kill you?
It includes that.
Were they sent to your phone or text messages or somebody told you?
It comes in various forms. And so, but I don't think it's important for us to, because if we follow that to, then it means people will use such threats to secure freedom to continue to do that which the law prevents. So I think, and it's not only me, my attorneys receive such threats every day. And not only in this case, other cases as well. Murder cases, armed robbery cases. Judges receive their share of the threats. It comes with
how do you stay safe? I mean, especially as you made the point, on the back of the conviction, you've seen an increase in the threats. How do you stay safe?
God is the protector of man, and I believe God protects me as well. Of course, because I mean, no matter what you do, the state cannot commit a certain level of security to. I
mean, in our case, a private organization, we invested in taking the people out of the jurisdiction. You are still sitting here.
Yes, that's what I'm saying. That
so you must definitely take beyond the prayers and God's protection.
Yeah, I mean, there are definitely physical, natural protection, and then I refer to God because that's the supernatural one. But the point I'm trying to make is that your protection, you can get the physical one. But even that, there's a limit to which you can, as a minister, a deputy minister, because the protection comes in levels. The president's protection level is higher because of the same reason, threats. The state cannot spend money on me as they're spending on the president's security. And obviously, the attorney who is conducting the case or assisting us to conduct this case will not get the same protection as I am getting. The point I'm making is that there is a limit to how much physical protection you can get, and even that is never enough because human beings can do so many things. So I would, for my own peace of mind and everything, I discount the physical one, even though yes, it's good, and just so I can sleep, I commit myself to
in the hands of the Lord.
Yes.
And those two star witnesses, are they getting any police protection?
Yeah, we've given them police protection.
Then the threats must have been very severe.
Oh yeah.
Against them. Just wrapping up on Wontumi, he has another case now, the 30 million Exim Bank. That is an oral case.
Yes, it's an oral.
The last time this was adjourned to allow you to finish the negotiations, I believe there's a plea bargain there.
Yeah.
They made an offer that you rejected.
Yeah.
Are you making progress?
We regrouped again to negotiate further, but I can announce that too has not made we've not made much progress. Because what we think is sufficient, the other side said either they don't have it or they so
this 30 million, how much are you asking them to pay?
That would be the details of the negotiation, which is without prejudice, and it's also covered by confidentiality, So it's enough for me to say that we have decided that we'll proceed with the case. So once the legal vacation is over, we will proceed with the trial. The law allows us to still have that conversation alongside the trial. So even though I would say we are still negotiating, we think that we have reached a point where we would have to proceed. If along the way we arrive at a fair conclusion or decision or plea deal, it's just a matter of informing the courts and then it ends. Otherwise, we don't want to spend time talking about this while
So you are not rejecting or closing the door to a plea bargain.
Yeah.
But you would focus on the trial.
Precisely.
While this other, plea bargain arrangements still happen.
Precisely.
But what you said is very clear that you know what you want from the plea bargain.
Yeah.
You put it before them and their counter offer doesn't meet it.
Doesn't meet it at all.
At all.
Yeah, significantly below what we are expecting. So we will proceed. And like I said, I think you put it even more accurately that we'll proceed with the trial while having this conversation on the side. If we reach a deal, we announce to the court that we have reached a deal. Otherwise, we
And educate me on plea bargain. Does it mean that the accused would have to plead his guilt and accept his guilt in the matter?
Not necessarily. It depends.
And that if we've reached an agreement, does that presuppose that he's accepted that he's guilty?
Yes. So there are options.
Okay.
There's one where he doesn't need to plead guilty before the court, so we can withdraw the charges completely based on the plea bargaining. So the Attorney General can negotiate and say, okay, you have caused us 30 million CD loss. We think that if you give us 60 million, that's times 2. We can drop the charges and then accept the 60 and let you go. And there are so many factors that I'm just simplifying. There are so many
hypothetical.
Factors, there are so many factors that go into this plea bargaining. But there's an option where Attorney General can withdraw charges and then let the person go. So you have seen that in a number of cases we have withdrawn charges and we have converted accused persons to prosecution witnesses. So those accused persons are not going to be tried and they don't need to plead guilty, but they are giving us more things than we probably would have achieved.
You got something in exchange.
Yes. So if you take the Wontumi, the witnesses, the two witnesses, for instance, they did not just forfeit the mining equipment and the gold and the things that were confiscated. They also said in addition to that, they testified on our behalf. They testified in defense of our case against the accused person, and we found that valuable.
Yes. You see, me okasa and I reminded me of, and Evans said that why is it not being given more security near them? You see, I said Russell to beat me now with the Russell side. Don't come in perfect, but on Galam say I'm to sometimes Anna Medma we Anna a yes type. Oh, that's a general and get as it's all call office. So I need a time document in a month. Oh, I had more office. Will you give a document straight up to convict yourself or implicate yourself? If you know the number of journalists, I never said it the angel to taking outside. That tells you the danger of some of the things that they do as prosecutors. And for those who report it, it's not everything we can share on social media. So people should always have that background and not think and sit comfortable in their room and think that okay, a document in the down, it's a cut to the okay, the no akofa. And yes, I but on him, I think that he's doing a good job. At least he's front and the last that the attorney general himself said that he has allowed him to do the prosecutions whilst he do a lot of the legal amendment, the laws, the policy issues, while he goes to court as a prosecutor. And that's the first time he's been a prosecutor. All his life he's been a defense lawyer, as I've heard him say on a couple of times. But for me, I think that President Kufuor can be an name at the point. Say that at the end of the day, we are all in the hands of the good Lord. I think that God will protect him. But I think that whatever the state must also do to protect him and the prosecution witnesses, they must do it, because they are not careful. There's a likelihood that it will disincentivize people to come forward and give critical information to convict people. In Timokaya, Wontumi Tano Brim case, a break or Danebe state prosecution, may can say a crook men can't say Wontumi be. Sometimes it's not even the people involved in the case. No, don't let your mind go there. So sometimes the people can act on your behalf without even knowing. As a normal governance, obitimi bibi Mahama nsoma no, but opeso yenya Mahama favor bedu na bia na ade no opeso yenya favor kwa no ase no kra. So people can act without the express approval of the people in these conversations and they can act so much, but at the end of the day they'll hurt you. And this country, you know, if you follow most of our criminal trials, so you just need to protect yourself. So sometimes I just want you people to also understand that you get it. And when journalists, especially in investigative journalism, there's a reason why whatever they do, whatever that they fault, I believe you must support them. It's not easy. One day, maybe they share their story. Rastos had to leave the country. Do you know what that means? The psychological trauma. We'll be telling them, no, I can't be the comfort of, no, go and do this, go and do this. As if you go there and the tennis on the silver platter. On the plea bargain, you know, is the figure, I don't know, let me not give you the details. But what I know is that it's woefully inadequate. In fact, my sources tell me that the government even believes that that thing is just a ploy. There's no money anywhere for them to just delay the process. That's what the source believes. I don't have any counter. I have some counter information, but it's not public information yet. And I think that for me, I've always said that 20 million should suffice for me, you to buy me state. You know. So they'll do the trial as and when they're able to actually get the money and tell the court that, oh, when yes, you can say you may continue trial and in plea bargain, that was also something that Wontumi and the team can also go for. I don't know what to make of all these things. Feel free, share that view in the comment section. We are not subscribing. I'm subscribing. I'm not clicking on the notification. The video be to my voice in I'm offending. I'll get it back in a few days. So that's social. See me here on my Ghana. See here. Bye bye.